welcome from myself as well. I'm happy to be moderating the discussion today, and I think we are moving very much towards practical proposals. I hope this is what will come out of today's panel. Because as we've heard, we often discuss how important it is to have independent and effective monitoring about what happens at the borders, about the respect of human rights, the operational human rights challenges for migrants, the local population, national authorities. And while it's clearly essential that we have independent monitoring, it is paramount that this information is passed on and is being used by national and regional authorities when they develop new policies and new legislation affecting the borders. And I think we've heard that already, is that NHRIs, but also many NGOs agree that there is a gap between the information collected and the recommendations made, and on the other hand, the way that regional and national authorities rely on this information in formulating policies and legislation. And very specifically, the EU Pact on Migration and Asylum and the current negotiations provide an opportunity for bridging this gap. But it can also be a risk if the information recommendations from human rights defenders, and that includes NHRIs, of course, if those information and recommendation are disregarded. Having said that, let us now turn to our inputs. Our first speaker is Petra Maroša, the representative of the upcoming Slovenian presidency of the Council. Mrs. Maroša is the Justice and Home Affairs Councillor for Visas and Border at the Permanent Representation of the Republic of Slovenia to the EU. And as you are all aware, the Slovenian delegation will hold its second presidency of the Council of the European Union starting from 31st July. It says, I think there's a mistake. It must be, I guess it's July to December this year. This will be a pivotal moment for advancing the negotiations about the different proposals under the EU Pact. So we are, of course, very interested to know what the main priorities will be in the field of migration and how the Republic of Slovenia sees the importance of relying on credible and accurate information about what happens at the borders in order to guide negotiations. Mrs. Maroša, you have the floor.
Thank you. Thank you very much. It would be indeed, personally speaking, very useful if we could start the presidency on the 31st of July. That would give us one more month to continue the preparations. But okay, I don't think that it's feasible. We'll have to start on the 1st, unfortunately. So first of all, of course, thank you very much for inviting me to this event and for giving me the opportunity to present you briefly the priorities of the upcoming Slovenian presidency for the second semester of 2021 in the area of home affairs, and more particularly in the area of migration and borders. Of course, when we were preparing the priorities, we didn't work in the vacuum. We have the trio presidency program as a sort of a broad framework, and of course we will be heavily building on the concrete progress that has been achieved during the German and the Portuguese presidencies in this field, so our trio partners. So I will take you very briefly through our priorities, which I can say are in principle focused on three substantial horizontal ones and then one regional. So the horizontal ones is definitely strengthening the Schengen area and enhancing control of EU external borders. I think the two go very much hand in hand. Then the second priority is the comprehensive migration management. And the third priority is to ensure a high level of security in the EU. I think that all three are very much interlinked and, of course, interdependent. And then the regional priority, I don't think you will be surprised there. We've chosen the Western Balkan region as our regional priority. So main focus in the area of migration and asylum. I mean, we all know we have the substantial pact on the table. Not everything will be possible to be done at the same time. So our focus will be, I would say, to establish effective and resilient asylum and migration management system, which will be based on fair share of responsibilities. In this respect, we will primarily focus on the establishment of the EU Asylum Agency. This is going to be our key priority, because we do believe that the stronger asylum agency that can better assist member states under the migration pressure would be a very, very important step and could contribute to making overall asylum system more efficient. We, of course, intend to continue discussion on the other proposals within the pact. And in that respect, we will, of course, as I said previously, build upon the progress achieved by the German and the Portuguese presidency. The Portuguese still have 1 month to go. So in some respect, we are still waiting where the specific file will land when we take over. Of course, we also plan to continue discussions in relation to external dimension of migration. We will try to focus on shaping strategic partnership with key third countries, contributing to shared migration management and improve the efficiency of return policy. In the area of Schengen and borders, we plan to focus on ensuring well-functioning, stronger, more resilient and robust Schengen, and of course, by that contributing also at the same time to better protection of the external borders. Key priorities in this field. We will continue discussions in different fora on the strategy on the future of Schengen, which the Commission presented yesterday. We, of course, also tend to bring forward the discussions on concrete legislative proposals which were tabled alongside the strategy. I'm speaking about the Schengen evaluation and monitoring mechanism. And at the same time, we will, of course, closely monitor the implementation of the EBCG 2.0 regulation, as well as the interoperability project. And in both respects, we will give or provide for the necessary guidance and recommendations and steering if of course needed. So in brief, I would say these are our main priorities that we will focus on in the next 6 months. I mean, I basically answered, I think, your first question, and concerning your second question, which is more related to human rights and protection of human rights at the borders in particular. I would say personally that, at least in my opinion, human rights considerations have found, I would say, a prominent place in the legislative proposals already from the start. Of course, there is always possibility and room for improvement, but I think that the awareness of how important these elements are has increased over the years. In some way, I could say that there has been a system of checks and balances somehow established. And I think that engaging with different stakeholders and partners, at the end of the day, we mainly or mostly achieved quite a balanced text and establish balanced compromises, I would say. Of course, I mean, I can already tell you that as the incoming presidency, we have been in close contact over the past months with various NGOs, UNHCR, International Organization for Migration. We have very carefully listened to their concerns, to their recommendations. They have been sent to, I would say, to policy. The policy level back home, and of course we will take all their recommendations and suggestions very seriously. We will carefully reflect on them and to see how we can, of course, factor that in the future negotiations on the legislative proposals within the pact. So I think I hope I didn't go over my 10 minutes. I think I can leave it at that. And of course, I will try to follow the discussion. I do have another meeting to attend to, but if there are any questions, I will be happy to answer them.
Thank you very much. And as you've seen, you reached the 8-minute limit. Thank you very much. That gives us more time for discussion after we've heard all inputs. And without further ado, I think we will take up your issues about efficient border or migration management systems, and more specifically about how to square that with human rights in the best way. I think that's something for the discussion we will have. Let me give the floor to our next speaker, Matthias Earl, Director for Borders, Interoperability and Innovation at the DG Home of the European Commission. Mr. Earl, you've been a guest with ENNHRI, but also with the German Institute and events quite often. It's good to see you again. We would, of course, like to know what the experience so far is at the European Commission in relying on information collected by credible actors such as NGOs and NHRIs about what happens at the borders and how we can better overcome the bridge between that information and the role of the Commission in proposing a new approach to on migration and monitoring in member states' compliance. Let me give you the floor for your 10 minutes. Very warm welcome.
Thank you very much, and I hope that Petra and the incoming presidency will agree that in the spirit of the close cooperation, the Commission and the presidency have, I can use her 2 minutes as a credit, if necessary. Thank you very much for the invitation, and let me start with a statement that exercising external border management presents border guards day to day with challenging and difficult decisions. I think this is something we should make ourselves aware of. In accordance with the Schengen acquis, they have to protect the external border, and they have to conduct operations of border surveillance in order to prevent unauthorized border crossing. That is their primary task. And for complying with this legal obligation, border guards may have to use coercive measures, like other law enforcement authorities as well, and of course within their respective mandate prescribed by national law. And the use of coercive measures must be proportionate to the objective pursuit and the situation where the need to use such force may occur. And of course, in accordance with union law, and that is the other side of the coin, such coercive measures must be in full compliance with fundamental rights. And this includes obligations related to access to international protection and the principle of non-refoulement. And I assume that everybody in the audience will acknowledge that there is a certain tension between these two sets of legal obligations. And we are confronted on a daily basis with examples and constellations where it is difficult to distinguish between legitimate measures to prevent irregular migration and illegal so-called pushbacks. The legal provisions are complex, and lawyers as well as courts do not always share the same interpretation of these rules. And for those who work in the field of border control, and I'm thinking here of national border guards as well as Frontex staff, this is, and I've said that in the beginning, a challenging situation. Doing their job exposes border guards to allegations of illegal actions, Sometimes these allegations may be unfounded, sometimes they may be supported by credible evidences. And in many situations, incidents are reported in the press and or brought to light by national institutions, for example, by ombudsmen, international or non-governmental organizations. And lately, members of the European Parliament have been increasingly referring to these alleged incidents in parliamentary questions or debates. And also third country nationals lodge directly formal complaints alleging violations of their human rights. So the situation is complex, and what can be now done to improve it? And how can we overcome, as you have said, Ms. Rudolf, the information gap? Also, the reply to this question is not easy, because there is no standard way to follow up on allegations of fundamental rights violations at our external borders. And let's be, in the beginning, very clear, it is the EU member states themselves who are primarily responsible for ensuring the correct implementation of their obligations under EU law. It is the national level having the resources and enforcement powers to do so. And therefore, national appeals authorities and courts play a very important role. And in this context, the European Court of Justice provides binding interpretation of union law via preliminary references. Now coming to the Commission. For us, one avenue available is to pursue infringement actions against the member states concerned for non-respect of specific provisions of the relevant asylum or border acquis. However, and that is something we have to take into account, such cases can take many years to reach conclusion and are therefore not necessarily the most effective way of responding, or at least not as a first resort. And let's also be clear that in many of these cases, the Commission currently faces evidentiary challenges. It is difficult to attribute conduct to national authorities through video, audio evidence, often of poor quality or doubtful authenticity. Evidence in terms of written instruction by national authorities is hard to come by. Alleged incidents at sea often occur in zones where it is not clear which rules apply. And moreover, incidents may appear to be isolated rather than systematic. Finally, and let me repeat this once again, the Commission services are neither responsible nor designed and staffed to act as an appeals or investigatory body for individual, I underline individual cases. Now, having said this, the Commission has paved the way, in line with the topic of this panel, to shape the development of policy and legislation in respect of fundamental rights and to narrow the information gap, and Petra has already referred to that as well. The recent Migration and Asylum Pact places a strong emphasis on the obligation to guarantee the right of access to asylum procedures and to safeguard fundamental rights. And very concretely, in the screening regulation, the Commission has proposed an innovative model, namely to oblige member states to establish a national independent monitoring mechanism for fundamental rights. Such independent monitoring, which would be characterized by the presence of independent observers who are able to report the objective truth in inverted commas, would be a very helpful control mechanism for national day-to-day practices at our external borders. And the Commission is currently engaging with the Fundamental Rights Agency with a view to establishing guidance and criteria that member states should and could take into consideration when establishing such independent monitoring mechanism. A key factor for the monitoring to work well will be that both sides, governments and civil society, will have trust in the neutrality and objectivity of the observers. If they are trusted as reliable points of reference, their presence will lead to a triple win for the migrants, for member states' authorities, and for the civil societies. The proposed monitoring mechanism under the screening regulation is still under negotiation, as you know, and it may take some time before it is adopted and will enter into force. However, of course, nothing prevents member states to already establish such independent monitoring mechanism, and the Commission also encourages such steps. Another track we are working on is the Schengen-specific framework of the Schengen evaluation mechanism. This mechanism is a peer-to-peer review tool verifying that member states implement correctly Schengen rules. And since national as well as European Commission experts are involved, it guarantees a certain neutrality. And the evaluation topics include requirements on data protection and respect of other fundamental rights. The current legal basis provides for paying specific attention to fundamental rights when evaluations are carried out, and it ensures that experts have undergone training in this regard. However, we, the Commission, have identified that these need to be further improved, and therefore the Commission has proposed yesterday, as part of its Schengen strategy, to also reform the Schengen evaluation and monitoring mechanism, so-called Tzavala mechanism. One of the objectives of the revision proposed yesterday is to strengthen the role of the mechanism with regard to the monitoring of the respect for fundamental rights under the Schengen acquis. In our impact assessment, in the run-up of developing the proposal, it was confirmed that this need and that be identified as a shortcoming the limited capacity of the mechanism to identify violations of fundamental rights, particularly at the external borders. So better ensuring the respect for fundamental rights is an important call that the European Parliament and other stakeholders expressed during their targeted consultation on the reform of the mechanism. And we have taken all these concerns into account in our proposal, which provides for, and I will give you a few examples, an increased role of the Fundamental Rights Agency. The agency will in particular be invited to make more regular submission of risk analysis. Secondly, to participate as observer in the evaluations of external borders management. Currently, the Fundamental Rights Agency only participates as observer in evaluations in the field of return. There should be a strengthened training on fundamental rights for experts, and there should be a specific reference requiring the use of evidence supplied by third parties, including national monitoring mechanism. The possibility to carry out unannounced evaluations without prior notice, and really without prior notice, if there are indications of serious violations of fundamental rights, is a further novelty in our proposal. Finally, the Tzavala reform also improves cooperation with relevant EU bodies, offices, or agencies, and that excludes, besides FRA, Frontex, and the European Data Protection Supervisor. Another important contribution to enhance compliance with union law can be made through targeted training and guidance for frontline staff, but also for judges, legal practitioners, and other stakeholders, with a view to improving enforcement and vigilance at the national level. And our agencies, namely Frontex, FRA, and the European Asylum Agency, have a central role in that process. Let me stop here. I think I'm within the 10 minutes, but you correct me. Let me conclude by saying that I hope that I could demonstrate to you the complexity of the issue, but also the fact that the Commission is acting with the objective to ensure better information and thus to narrow the information gap, and that applies in particular to the Asylum and Migration Pact, which Petra has mentioned, but also within the yesterday's proposal on the Schengen strategy, and in particular the legal proposal on the reform of the Tzavala mechanism. Thank you very much.
Thank you very much I think you rightly explained the complexity of the issue, and it's great to have your view on the latest developments, and thank you for keeping within the time. I think we'll come back to a number of points that you made and may want to discuss in depth. But before doing so, we still have two more speakers that I would like to invite. The next is now our switch from an institutional point of view to an NGO. I very warmly welcome Milena Zajović from the Border Violence Monitoring Network, which, as everyone knows, has been doing remarkable monitoring work in the field. And you regularly publish reports about pushbacks, violence, and other human rights violations at borders throughout Europe, particularly in the Balkan region. And of course, we would like to get your view on what is maybe lacking in terms of follow-up on that information by regional authorities. And we would like to know your recommendations for bridging the gap between monitoring at the borders and the accountability, remedies, and prevention of human rights violations. Mrs. Zajović, you have the floor.
Thank you very much, and thank you for the invitation. So, as you have kindly pointed out, I am here on behalf of the Border Violence Monitoring Network, which is a coalition of 14 NGOs and collectives dedicated to monitoring and reporting on human rights violations at the so-called Balkan route. 4 years ago, our network developed a common framework for recording testimonials and supporting evidence, which are fact-checked and published in our open source database. And the testimonies are also collected in the Black Book of Pushbacks, which is, I can show it, 1,500-page thick archive of printed evidence that was recently presented in the European Parliament and then shared with the European Commission, as well as national human rights institutions. And if you look into these resources, you will learn that only our small teams of volunteers managed to collect testimonies of pushbacks affecting nearly 18,000 people along the Balkan route. And this is just the tip of the iceberg. Our case reports include hard facts such as geolocations, demographics of victims, pictures of injuries and medical documents, as well as detailed description of the incidents. They also include analysis that provides deeper insight in trends such as disproportionate use of violence that affects 85% of victims at the borders of 11 countries along the route that we are monitoring. It allows us to understand that, for example, 52% of pushback groups subjected to torture or inhumane treatment by Greek authorities contain children and minors, or that children were present in 54% of cases involving gun violence at Croatian borders. And of course, the borders officers, as the Mr. Earl pointed as well, have the right to patrol the borders. But when the beatings, sexual abuse, dog bites, robbery, and systematic denial of access to asylum procedures become a widely recorded norm, it's a bit cynical to only talk about allegations or isolated incidents. The Black Book of Pushbacks is divided in 2 volumes, and one of the books is dedicated to Croatia entirely. But according to Croatian government, the violations are not happening. And if you ask Hungary or Greece, also heavily featured in the other volume of the book, they will often tell you that the pushbacks are actually legal. They might just frame them a bit differently. In all of the mentioned countries, parallel with attempts to legitimize rights violations at the borders, we see attempts to delegitimize the reporting work of CSOs and sometimes even national human rights institutions. Out of 14 members of our network, at least 7 NGOs experienced criminalization or other forms of institutional attempts to silence our advocacy teams and to stop our monitoring activities. And I think some of you are also aware of the pressures the previous Croatian ombudswoman faced when she tried to investigate cases of pushbacks. So in this atmosphere of shrinking space for civil society, national human rights institutions often seem like only allies for watchdog NGOs and networks such as ours. It is because they are and should be the pillars of human rights in the countries that they operate in. And they are and should be bridges between CSOs, governments, and institutions. But what happens when the pillars start shaking under political pressure and that bridges start collapsing? What happens when ombudsperson's offices brush off alarming cases of pressure on human rights defenders, like we had this year in Croatia? Or when it takes them 4 years to do one field visit and produce an interim report on pushbacks, only to say nothing was proven, like it recently happened in Greece? Or when a Slovenian ombudsman fails to investigate 10,000 chain expulsions per year from Slovenia that are even publicly recorded by their Ministry of Interior, just because victims in dire situations of the Bosnian border camps didn't have the means to file individual complaints and send their powers of attorney across 2 sealed borders. In recent years, the issue of pushbacks is really one of the gravest human rights violations in this part of Europe. And I'm not mentioning these examples to shame any institution, but to illustrate the obstacles and frustrations we as human rights defenders are facing when we are trying to bring the evidence to the attention of the institutions in which we put a lot of trust. Of course, we are aware that human rights institutions are not omnipotent and that the true power and responsibility lies in the hands of European Commission. They're the ones pouring more and more money to countries such as Croatia and Greece for procurement of drones, vehicles, and other equipment that is actually used every day to perpetrate pushbacks. They're the ones turning a blind eye to serious violations of Article 4 when giving the technical green light for Croatian entry to the Schengen area. And after all, they're the ones being so reluctant to start infringement procedures that member states are not even taking that possibility seriously anymore. And it leads to widespread impunity. But they're also the ones that can and should take in account inputs from civil society and human rights mechanisms when developing new approaches to migration policies. And the Commission really recently did introduce the new Pact on Migration that recognizes the need for the independent border monitoring mechanism, an idea that has been unsuccessfully tested in Croatia since 2018. And in these 4 years, this monitoring mechanism became a sort of a holy grail in our field of work, a mechanism that would, in theory, prevent pushbacks from happening, but in reality, it simply doesn't exist. We even had a bit of a scandal last year when it was revealed that Croatia didn't only misspend the 300,000 euros allocated for establishment of such mechanism under the EMAS grant in 2018, but they also worked with the officials of European Commission on amending the final grant report in order to cover up this mismanagement. And in the addition to outrage that it triggered in the European Parliament, the scandal even triggered an investigation by the EU Ombudswoman. But instead of imposing financial repercussions, which is also a mechanism at disposal of the Commission, Croatia was awarded by the Commission with the increased grant for the next funding cycle in order to improve the non-existing mechanism. And we are especially concerned by knowing the test monitoring mechanism is currently being developed by the Croatian Ministry of Interior, in collaboration, of course, with the Commission. And sometimes I wonder, am I the only one thinking, what might go wrong if the ministry that is responsible for the most brutal pushback practices in EU would be tasked with developing a mechanism to basically monitor itself? It also seems that this illusion of independence might be strengthened by inviting representatives of ministry-funded, dependent, and often silenced NGOs to be part of this allegedly independent mechanism. And the most worrying part is that the monitors would be only placed in the official border crossings, so far from the green borders where the pushbacks are actually happening. So they would effectively be able to monitor nothing. And if we don't want to have another fig leaf instead of the real monitoring, the Commission needs to take this criticism into account. A truly independent monitoring mechanism should be led by the national human rights institutions, in collaboration with monitoring NGOs on the ground, and with involvement of the Fundamental Rights Agency and the Council of Europe. The mechanism should be funded directly by the Commission or through an independent agency, to avoid political pressure from the national authorities that currently have the power of distributing the EU funds to their preferred NGOs. And in order to really prevent pushbacks, the monitoring mechanism must include not only monitoring of the triage centers and asylum procedures at formal border crossings that most victims cannot even access. The monitors need to be able to implement unannounced visits to green border areas and police stations. And it also must see better cross-border collaboration in testimony collection from the affected population, as the ineffective mechanisms that are currently in place or allegedly in place only take in account the cases of those who were able to remain in European territory and therefore were not necessarily the victims of unlawful practices. Such a monitoring mechanism would benefit from an alarm system that could be triggered by potential asylum seekers in situations where their fundamental rights are violated. And to conclude, in addition to that, we urge human rights institutions to independently take a more proactive stance in investigating pushbacks, to insist on better monitoring and accountability mechanisms, and to provide more support and more dialogue with targeted human rights defenders. We urge them to trigger investigations against law enforcement according to their mandates, to start collaborating themselves in cross-border investigation that take in account testimonies of victims in the border areas, and to strengthen peer review mechanisms among the ombudsperson's offices. And we believe these efforts are crucial and need to be done for the sake of human rights standards, rule of law, and the Paris principles that we all believe in. Thank you.
Thank you very much for this perspective. And I think this will give us a lot of food for thought and discussion. But before we do so, I would like to invite our own Eva Tzavala for her perspective from the point of view of the Greek National Human Rights Institution, and particularly how you see the role of NHRIs in calling for respect for human rights during the negotiations and later implementation of the legislative proposals under the EU Pact. Eva, you have the floor.
Thank you, Beate. After such a sweeping presentation by Milena, I will treat something more technical, the role of NHRIs at shaping policy at the regional level. So bear with me for the next minutes. And I would like to start with the basics. At national level, as we know, states have a clear obligation to consult NHRIs on all policy and legislation developments that concern human rights. And indeed, on migration matters, NHRIs are often called by governments to provide their opinion, expert opinion on relative bills and proposals. But even if we are not invited, at our own initiative, we comment on the proposed amendments. However, it is not common for states to ask the opinion of NHRIs on draft EU legislation. To my knowledge, there are only few governments that have already asked their NHRIs to provide advocacy in the EU Pact. We have the best practice of Slovenia. They have already asked the Slovenian NHRI to provide advocacy in the EU Pact and screening regulation, I believe. So one important aspect of NHRI's work is and has to be at national level, assisting governments with the negotiation process of the EU Pact. Generally speaking, we note that there is a lot of discussions going on at regional level. However, we don't have a lot of open dialogue at national level. There is no dialogue between governments and relevant stakeholders like NHRIs and civil society. For instance, in Greece, I will take our own example, civil society feels a protection gap in practice regarding refugee and migrant protection. And we believe that they shall be consulted and bring their abundant experience from the field, since we're talking for borders, to state authorities that they are now managing the negotiations. So a bottom-up approach must be adopted, and NHRIs are very well placed to foster discussion at national level. Since, of course, our panel addresses the question of NHRIs advocacy at regional level, let me clarify that NHRI should always be consulted and considered in relevant human rights policies and laws, also at regional and international level. This is our approach. Although we are national institutions, as you know, we have a specific role of bridge building between international standards and national practice. So we bridge the protection gap between rights enshrined in law and rights enjoyed in practice. And of course, the very concept of NHRIs, our foundations lay in international law, the Paris principles. We are national bodies, but we account for our independence before international organs. So NHRIs must be recognized, in our opinion, as relevant actors in legislative and policy processes. Our regional network, ENNHRI, facilitates our engagement at regional level through strengthening, supporting and connecting NHRIs. And according to the Paris principles, as we know, there is an a recommendation of cooperation between NHRIs, UN regional institutions, and other national institutions competent on human rights matters. My understanding to this point is that on the one hand, NHRIs have to cooperate with other human rights bodies, but on the other hand, these other bodies need to enable NHRIs to fulfill their mandate by maintaining open channels of communication and actively encouraging bilateral cooperation. And it's not just a matter of cooperations. We are 28, almost 30 years after the Paris Principle. We are beyond that. We have some best practice in the Council of Europe framework. So I will cite some examples and I will transpose them in the EU level. In the Council of Europe, NHRIs are acknowledged as key partners for development, dissemination, implementation of legal standards. There was this recently adopted recommendation by the Committee of Ministers on effective, pluralist, and independent NHRIs, and states are advised, and I'm quoting the recommendation, to explore ways of developing a stronger role for and a meaningful participation of NHRIs and ENNHRI in across all Council of Europe bodies. As highlighted in our previous high-level event that we had last April and follow up this recommendation, NHRIs should have more consistent participation across Council of Europe bodies, building on previous good practices like the participation of ENNHRI as observer in intergovernmental committees. We have already close cooperation between the Commission for Human Rights of the Council of Europe and ENNHRI and NHRIs. We have also good working relationship with CPT, Grevio, and other human rights monitoring mechanisms of Council of Europe treaties. NHRIs, of course, are sources of reliable information for human rights monitoring bodies in the EU family, also in the Council of Europe. And another strong, impactful tool that we have as NHRIs in the framework of Council of Europe is the possibility to submit third-party interventions before the Court of Human Rights on pending cases, and then follow up by submitting communications at the execution phase before the Committee of Ministers. So what I would like, I want to raise by these examples is that we have moved from cooperation to a meaningful participation. And we should reflect at this point on the requirements, how to ensure effectiveness and sustainability of NHRI participation. First, NHRIs must, of course, be regularly informed about relevant activities. And I heard Matthias talking about the bridging the gap on information. This is important from the part of regional actors. Second, we need institutionalized, let's say, special channels for consultation with NHRIs and other human rights bodies that have a different mandate, like NPMs or quality bodies. We are not state bodies, we're not the civil society, we have special standing, and the dialogue between the regional organs and NHRIs and ENNHRI must be adapted to the particularities of our mandate. And finally, in order to be able to contribute effectively and independently, we need support, concrete support by regional organs when NHRIs are under threat or when we just lack resources to perform our monitoring activities or other. So let's move now to the EU context. How will we adapt to the developments there? Since Beate talked about those particular asylum migration and the compact. At EU level, okay, we have the European Council has already acknowledged NHRI's role. On EU Charter, we have the European Parliament and EU Commission already being involving NHRIs and ENNHRI in the rule of law consultation processes. We discussed a lot last day on that. On asylum migration matters, the Parliament has adopted a resolution recently that NHRIs play a key role in the monitoring forced return procedures and migration detention monitoring visits. So specifically on the EU Pact on Migration and Asylum, before launching the new EU Pact, neither European NHRIs or ENNHRI had been consulted by the European Commission prior to the launching of the migration asylum package, and in a formal, structural and inclusive manner. Of course, the EU Commission was involved in closed consultation processes before launching the pact with different stakeholders. However, this procedure was not an open public procedure. We need open and transparent procedures of consultation that they are subjected to public scrutiny. I think also Tineke Strik raised this yesterday. And NHRIs, given the special standing, as we said, in role, need a separate channel. This is important for me. And the only public consultation process that took place was mid-August 2020, if I remember correct. It was for a few days, 20 days or more. And it was not based on the actual legislative package, rather on a concept note, a roadmap. So in my view, the European Commission should actively encourage the participation of external interest parties in the development of European policies. Starting the consultation at an early stage improves the effectiveness of policies and reinforce the involvement of the interest party, also the general public. And don't forget about the migrant communities themselves. There was this best practice of establishing an expert group composed of persons with a migrant background by the European Commission in view to participate in the integration policies. I don't know what has happened with that. Maybe if any participant know, we can follow up to see how migrants, asylum applicants, refugees were involved in these policies. And regarding the specific issue of how NHRIs monitoring at borders may contribute effectively to the advancement of regional developments at EU level and in relation to the pact, I will give you a specific example based on my background on the work that we are doing in an asylum migration working group. Part of our monitoring activity these last 2 days has been the evaluation of the accountability mechanisms already in place at borders for addressing human rights violations. Okay, we found that the findings are, like Milena explained, there are multiple accountability mechanisms already in place to address the misconducts by national authorities, such as the Boots institution, police internal oversight mechanism, judicial authorities, of course. And we have also where Frontex is operational, Frontex personnel is deployed, we have also the Frontex complaints mechanism, but none of them are working efficiently and effectively. So building on the experience of European NHRIs and specific findings in the field, ENNHRI presented last March 10 concrete recommendations in relation to the establishment and functioning of independent national monitoring mechanisms at borders. You can visit the documents on our site, in the ENNHRI site. ENNHRI advocated for truly independent and adequate resources mechanism vested with appropriate expertise and powers. What I would like to raise is that NHRI's role is not clear in this aspect. The text of the screening regulation says that international organizations of society may be invited to participate in the mechanism. It doesn't say anything about NHRIs. Can NHRIs be designated as national monitoring mechanisms, or what's their role if they're not designated? We need obligation of cooperation enshrined in law. And beyond that, and this, would like to close with this, beyond that, NHRIs believe that there is a room for improvement in the EU Pact in relation to strengthening human rights standards. We worry about other aspects too, about the risk of making the border procedure the norm, about the widespread use of immigration detention. There are much more issues, and we can discuss them in the Q&A session later on. Thank you very much.
Thank you very much, Eva. Before, in view of the time, and we will move forward as follows. There are some questions addressed to Mr. Earl that I will highlight and would ask Mr. Earl then to answer because he has to leave by 11, and then we will take up a few other issues that were brought up. You all can see them in the questions and answers section, and I will try to bring them together in a little bit. And let me start by saying I think we see some comments that show how impatient civil society organizations, citizens become by seeing what is in the reports of the Border Violence Monitoring Network. And I think and maybe, Mr. Earl, you want to respond to whether the Commission will take steps, because as you rightly pointed out, the Commission looks at not at individual cases, but at systematic points. That would be one issue. I would like to emphasize in this respect that when we speak about ill treatment of migrants at the borders, of pushbacks, I think we all need to be aware that this is about fundamental right of people to have access to asylum procedures, and that if we disregard their rights, this is undermining the very fundament on which the European Union is based. And I think that, so I think we're all aware of the seriousness of what is at stake. So that would be one issue of the question. A second one that I see from the question and answer section is the point of how can maybe on the role of the screening regulation, the monitoring mechanism, and particularly the role of NHRIs, and how can the European Union strengthen those mechanisms, strengthen NHRIs with respect to their powers, their room of maneuver within states, and their financial support, and how can this be extended to to monitoring Frontex? Would that be, who would be doing that? So maybe those pointing to taking up these 2 points. Mr. Earl, please.
Thank you very much, Ms. Rudolf. And if you allow me, I will make 2 references to comments by the previous speakers. First, with regard to Milena Zajović's presentation, let me just say, and I hope that I made that clear in my introductory statement, it cannot be an either-or of financial support of border management equipment and making financial means available for the protection of fundamental rights. It must be both. We have to have an effective border management. I think this is in all of our interest. And at the same time, we have to see that this border management is managed in line with the fundamental rights. And on Eva Tzavala's comment, just to say that on the Schengen strategy and on the proposal for the Schengen evaluation mechanism, we had a public consultation in the beginning of this year. So we have consulted the public, and we also have both on the Tzavala mechanism, but also on the upcoming proposal on the Schengen Borders Code impact assessments available. So I think the Commission has fully done its job in this respect. Now coming to the question, and I'm grateful, Ms. Rudolf, that you refer to the fact, we are not an investigation authority, the European Commission, for individual cases. This is on the national level, but of course we need to monitor, whether there are real systematic problems, and not only that, we have to intervene if there are allegations in this respect. And let me also say we do that. Commissioner Johansson is in constant contact with ministers in order to discuss these questions. And she has also several times made that public and appealed in public, to respect the fundamental rights. For Greece, we now have within DG Home a Deputy Director General who is chairing a task force, or heading a task force, which is in constant contact with the Greek authorities in order to improve the situation on the islands with regard to the system, etc. A word also to Milena Zajović with regard to the situation in Croatia. Let me inform you that the Croatian authorities by now have finalized the text of the legal agreement that establishes the independent monitoring mechanism. So we are very happy about that. And we hope that the agreement will enter into force upon all the stakeholder signatures still in June. So this is our hope. And then I think we would have made a big step forward in this respect with this independent monitoring mechanism. And we are also providing funding for this mechanism via the emergency aid granted to Croatia. And currently the grant agreement in this respect is prepared on the technical level. And this is also an important point to say. European money is available to fund fundamental rights projects. Let me maybe finally say a word on on these national mechanisms, I think what is important, and I hope that you will agree with that, it is important that there cannot be a passepartout. You cannot have one mechanism which you now apply in all member states. Why? Because we have to take into account the given structures. There might be ombudsman, there might already be structures. So I think we need to see that we develop tailor-made solutions in this respect. And that brings me now to the European level. I think we are building up in Frontex, and it's still a process of also building up. Many things have been done, but it's still a process of building up on the basis of the Frontex mandate, which only entered into force 1.5 years ago. Frontex has a consultative forum. Frontex has an independent fundamental rights officer, and the new one has just been appointed, Jonas Grimheden. Frontex will have fundamental rights monitors. We are in the process of recruiting them. They will be also independent. They will be on the ground. Frontex cooperates very closely with the Fundamental Rights Agency, who is also on fundamental rights issues, taking part in the management board. And so I think, that with regard to the European structures, we can credibly say, that we are doing a lot in order to ensure that the fundamental rights are respected at our external borders. I hope that I replied to the questions you raised, Mrs. Rudolf, and I ask for your understanding that I will have to leave now because we have an important meeting with the Commissioner. Thank you.
Thank you very much, Mr. Earl. Thank you for joining us, and we hope to remain in close exchange with you because NHRIs and civil society organizations, I think, have a lot to bring and to make sure that the member states respect the human rights obligations that they have under EU law as well as under international human rights law. So thank you very much.
Thank you very much, and we are happy to keep in touch. Thank you. Bye-bye. Have a good day.
Bye. I think we have a few more minutes for a kind of second round. Again, I think our speakers have seen the questions in the question and answer section, but if and maybe you want to respond and react to what has been said by others, but may I just take up a few points. Two speakers referred to the chain expulsions that took place in Slovenia, and there's one question directed to Ms. Zajović, and that is how can NHRIs get engaged in that issue? And on that issue, and the question to Mrs. Maroša, which is how does the Slovenian government intend to deal with that issue? And it seems to me that there is a question that is directed to all speakers, and that is whether the code of conduct for border guards is that enough to ensure respect for fundamental rights? So I would give the floor to Mrs. Zajović for your reactions and answers.
Thank you. I think both Mr. Earl and I basically referred to same things, of course, from different perspectives, and I think it wouldn't be maybe fair to refer to some of his points since he is not here anymore. But I'm very happy to expand on this issue of the chain expulsions from Slovenia, because according to official statistics that are released by Slovenian authorities, an average of 10,000 people are expelled from Croatia based on the abuse of readmission agreements. Bilateral readmission agreements that were signed between, for example, Italy and Slovenia, Slovenia and Austria, and of course, Slovenia and Croatia. These readmission agreements date back to the 90s, and they have been written and signed much before this large humanitarian crisis, but also human rights crisis happened. Faced with a lot of allegations about illegal expulsions of people from the European territory, some member states thought of digging up these readmission agreements that they're now using to return people to their previous countries of entry. But the problem with this is that even though this is a sort of a formalized procedure, so not a pushback across the green border, but actually a handover between the representatives of different national police authorities, is that access to asylum procedures is not granted to these people. Their wish to ask for asylum is very often ignored. They're just handed over in this chain manner. And then in the end, when they end up in Croatia, they're put in police vans and pushed back illegally over the green borders. There are two very important rulings that were reached this year in Slovenian and Italian courts, confirming that this is actually in violation of international law and that it can be considered a refoulement because of what is happening with the people once that they reach, based on these readmission agreements, Croatia. And this is the perfect example where national human rights mechanisms actually could engage in cross-border collaboration, because we know that their mandate is limited often to the national territory. But this is the perfect opportunity, for example, for Slovenian and Croatian ombudsmen or ombudswoman to start collaborating on the issue and to start proposing policy changes. And I would say it is also a job for the Commission to recognize that even though there is no legislative change in either of these countries that might help to trigger infringement procedure quite easily, that there is a formalized practice that is now proven in the courts against European law. And in that sense, I think there is also potential for some action there as well.
Thank you very much for this view, and I think for the strong point you've been making. Eva, please.
Yes, I would like to comment to the first question, the Code of Conduct for border guards and law enforcement situations role. And based on NHRI's reporting and our experience, let's start with some data. In Greece, only two cases or 3 cases per year reach judicial authorities of pushbacks. So, and even those cases are not thoroughly investigated, they don't reach into a successful result, let's say, due to the lack of evidence that everybody is stating. We have a big issue on that, and then that's where NGOs like the Border Violence Monitoring Network can help in with the evidence, concrete evidence, to substantiate claims on pushbacks. And so I believe that we haven't much explored the role of the judiciary in all these procedures, because, okay, we have the independent monitoring mechanisms. Sometimes they work, sometimes they don't work, but the natural judge, I mean, we need to secure first access to justice for the victims. So this is a whole other discussion, how we enable victims to access justice and support them. And then once the cases reach the judicial authorities, how we assist the judges, or how the investigation procedures, official investigation procedures, to reach a result and address the violations of victims. So this is a whole different issue. And I would like to launch a discussion on that between NHRIs and other partners. Thank you.
Thank you very much. Before I close the session, I think this has been very, very rich, and I would particularly highlight the last issue that both Milena and Eva have been making, and that is that we need to think about further instruments, for example, using the evidence collected in courts, so to increase the visibility and to increase the statement by independent bodies on what is happening in border regions, because this is about the protection of our common fundament of the European Union. I think that's extremely important, and we at ENNHRI will certainly will be discussing of how we can bring this forward to push the issue, and I think that we've also seen that NHRIs and NGOs on the domestic level should think of how they can join forces and develop ideas for the mechanisms that would be necessary in their country to ensure an effective independent monitoring, and go with that into the discussions and the engagements with their respective governments. Having said that, I would like to conclude this session thanking our speakers, those present and those that had to leave already, for very stimulating input. Thank you very much, and see you in 5 minutes.